So welcome everybody. I am Demi Radeva. I'm the founder and CEO at Acros Advisory. We help companies with go-to-market strategy and especially with the focus on business-to-business sales. And one thing that I have kind of experienced over the last few years of attending various conferences and participating in various industry events is that everyone seems to focus on the problem, and I get extremely frustrated with that. And so I decided to create this forum where we get to highlight a solution that's making a true difference in the industry today. And so I'm very excited to have Tim Michaels with us today. Tim, can you tell us about you?
Yeah, thanks, Demi. My name's Tim Michaels. I'm the founder and CEO of HealthRate. I've been in the healthcare space the entirety of my career, a little bit north of 30 years to date myself. You can see a couple credentials there on the screen, but have really been working in the reimbursement space and how the dollars flow through the healthcare system space here for the last dozen or so years. So it's great to be here today, and I look forward to the conversation.
Awesome. Quick disclaimer, neither of us is a lawyer. So putting that out there on the table, if you do have any legal questions, please talk to your lawyer, or we have a few in attendance actually today, so happy to make any connections that you may need. What we're going to be discussing today is really the industry perspective, what Tim and I are seeing as a big market opportunity and a big market problem that is sort of unfolding in front of our eyes. And so we wanted to share that, and we'd love to hear from you. Are you also seeing the same things? And then as part of that discussion, we'll also present a solution to this problem that we're both experiencing. So the objectives for today is to really create awareness about ERISA, what is it, and the latest challenges. We're not going to get too much in depth because we're assuming that most of you should kind of have some background or be familiar with the ERISA. Or if you need more in-depth information or have follow-on questions, please let us know. Happy to answer that. We'll also discuss some implications of recent lawsuits that we've observed, and then we'll talk about the strategic considerations then that self-funded employers must think through as it concerns what we're noticing. And then last but not least, we'll talk about tools and concepts and case studies that we hope that we can all learn from to help you protect against ERISA risk. So what are we noticing and why are we all here today? There's really three major forces that we've noticed are coming together, and all of a sudden we have all of these entities that are being exposed to ERISA risk, which were not exposed before. So what are those landscape shifts? First, what we're noticing is litigation is accelerating. There's more and more plaintiffs firms. They're actively looking for new areas to apply ERISA, and Tim will actually dive into a few of those examples and lawsuits today. Secondly, we're noticing legislation changes, specifically transparency laws, are now exposing what we were not able to see before. So the pricing of healthcare has historically not been visible, and now with the transparency law, that's changing and really creating this exposure risk. And then last but not least, workforce, especially post-COVID, we're seeing a growth in remote workforce and more folks kind of moving and working from various locations and are traveling to get the care that they want, which is exposing everyone to potentially more out-of-network care and more variation in the cost of care as well. I was going to ask Tim, do you have anything that you'd like to add to the trends that we're noticing?
Just a few call outs to hammer home some of the points you made, Demi. If you look on the logos on the left there in the litigation, take a look at the variety of firms involved there. Those are not just employers. Those are really every part of the value chain in healthcare benefits. You'll see Mayo Clinic on there. They're actually a defendant as an employer, not a provider. So we can talk about that later if you want to. And then really the legislation has made things more visible. To Demi's point, a lot of this data wasn't visible before. There are still some pretty severe limitations to what is and isn't visible, but it's put a spotlight on things. It's attracting class action law firms, along with a couple of these SCOTUS cases we're going to talk about. So that visibility, that focus, particularly in the PBM space, it is really ramping up the risk and making this a burning platform.
Lovely. All right, so what are the basics? Again, we're not going to go too much in depth, but just for the purpose of the conversation today, we wanted to cover some of the basics. In an essence, ERISA really governs how benefit plans are managed, and it creates fiduciary duties that are tied to how money is spent and how decisions are made. Two core obligations as a result of ERISA are that you must act in the best interest of the plan participants, and you must act with prudence, meaning that you have to have a disciplined and informed process for how you're selecting coverage, networks, and benefits. And so I guess the main thing that I want to call out here is that this is not just about the outcomes and how expensive or how cheap care is, but it's also about how decisions are made concerning care, concerning networks. And so you're going to be judged on not just what you decide, but how you decide. What's the governance? What's the reporting? What's the disclosure procedures? And so if you control plan spend and or influence decisions or structure how care is paid for, you may be a fiduciary. Tim, how would you define a fiduciary?
So we'll talk about that throughout the deck, but there's a couple of terms on this slide that Demi hit that you're gonna hear a lot today. One is discretionary authority. If you've got any type of discretionary authority, whether it's formally documented or not, you're probably a fiduciary, or at least somebody's going to make the argument that you're a fiduciary. The other one, on a little more positive or less scary note, is prudent process. So nobody is expecting you to get exactly the right answer or the optimal answer every time, but you do need to have a prudent process and one that you can document and prove. So those are two terms that we'll be talking about. Again, I'm not a lawyer, neither is Demi. It's not legal advice. But you're going to hear me talk about lawyers a lot today and some of the folks that have been reaching out to me and asking questions and where I see them spending their time.
Great. So I'm curious, Tim, we've seen this before. Can you talk about the history of where have we seen this happening before?
Yeah, so those of you that have been in benefits a long time, so it's a little bit of Groundhog Day with some of the 401k fiduciary lawsuits and the precedent that set. So years ago, a firm by the name of Schlichter-Bogard set some precedent. They won some big cases that really drove home a lot of the concepts we're talking about here. And among other things, really, held employers financially liable if they were failing their fiduciary duties. So for example, if you were paying Fidelity $10 per member per month for administrative cost on your 401k, and you could have got it for $5 from Vanguard, that's a breach. That's actually a pretty concrete example of something that happened and somebody that lost a very, very large lawsuit because they were overpaying relatively small administration fees. And we're going to talk about this last April, the same framework, the same firm, Schlichter-Bogard again, they won a case, Cunningham versus Cornell at the SCOTUS level, that essentially sets the same thing. It applies all of those rules and those affirmative defenses to the healthcare space. So we see a lot of parallels between what happened a while back in 401k and now what's being brought aggressively to the benefit space.
Mm-hmm. And now I'm curious, what has been the change? What we talked about a few major trends that are leading to this change, but was there something that changed in the law?
Yeah, and the short kind of cynical version is, if you will, it got a whole lot easier to sue people, particularly employers. And the case that did that is Cunningham versus Cornell. It is an opinion issued unanimously by the court last April. Judge Sotomayor authored the opinion. And really the major shift there, it didn't shift ERISA, it didn't change any of the laws of ERISA, but it changed things to an affirmative defense. And this is what opened up the floodgates for 401k too. So one of the major implications of that decision was, and previously, if I was an employee and I wanted to sue you for a breach, I wanted to sue my employer or my plan for a breach of duty, I would have to have a plausible claim or some type of evidence that says, hey, I know that I'm overpaying for, say, prescription drugs. I know you're benefiting on the back end for that, or I know there were better alternatives available. I would have to bring that case kind of proactively, if you will. What this decision shifted or changed was now the onus is on the other side. It's on the defendant to provide an affirmative defense. So now if I'm an employee, the bar is much, much lower for me to start a lawsuit. I can simply allege that, hey, I'm overpaying for those same prescription drugs. I can't prove it because I can't see all of your data, but that doesn't matter because you're required by law to prove it to me. You have to be able to show me that you followed a prudent process, that in your discretionary authority, you are being a good fiduciary of my dollars. If you can't do that, you've got a lot of risk. So that's really the major shift that happened in April. Not to completely kill the slide here, but December, actually, I believe it was Christmas Eve, Schlichter Bogart again, filed, you see this in the bottom right, 4 new lawsuits exactly in this space, following up on that precedent. And you'll see a number of firms included there. Again, the breadth, it's everybody. United Airlines is the employer, CHS, even LabCorp, a lot of brokers, consultants, Mercer Gallagher, WTW. They kind of hit everybody with this. And we'll talk a little bit more about the specific allegations in that case as we go. But April, things really changed precedent-wise. Actual lawsuits with, potentially very large liability actually started getting filed and applied in December of last year.
Mm-hmm. And one of the keys for me is that plaintiffs had to prove they were harmed and that the harm was unreasonable, and that required data that they didn't usually, have historically. But now we do, and I'm excited for us to talk about that as well. But before we get there, I did want us to spend some time talking about the Cunningham versus Cornell University case, as that was also a pivotal case. Tim, any thoughts on this one?
Yeah, so again, it was unanimous. We're not going to get too technical, but you may see reference to section 406 and 408. And there's good news, bad news here. So again, this is existing law as ERISA. This isn't anything the court changed. It's simply that affirmative and burden of proof that shifted. 406 basically says you can't self-deal, right? You can't funnel business to your other places that you have a financial benefit or some other type of benefit in. So you'll hear us talk about implied benefits, indirect or derivative benefits. That's really what 406 means is don't line your own pockets with your subsidiaries or affiliated entities. 408 is the good news. Now, certainly, nobody expects you to be able to administer your health plan or your benefits by yourself. You're going to need partners and vendors for that. And pretty much everybody needs a TPA or an ASO. I can't think of a single employer working without one of those. So you can do that, but there's some rules to the road, and to make sure that you're not violating 406, that's really where the risk comes in, what you got to be careful for.
Mm-hmm. So if we take it home, more cases make it past the motion to dismiss, and most cases also don't go to trial; they settle. But ultimately, litigation becomes a cost center, even if you win, and so there is a big risk here. And Tim, some of the dollar amounts that we've seen are pretty big.
Yeah, I don't want to
Kind of give us some range, maybe, on what you've seen.
Before we get into dollars, I don't want to bury the lead here too much, but and if anybody's interested, let us know and we'll send you a copy of the Supreme Court opinion. But they even acknowledge that they know they're lowering the bar for these types of lawsuits. And Demi kind of hit on it without saying nuisance lawsuits. So even if you're completely compliant and you're in great shape, unfortunately, you're still going to have to spend time and money to have that affirmative defense. And even if you're right, it can cost you several $1 million in legal defense costs just to prove that you're right. So one of the things we're going to be talking about today, and again, I'm not a lawyer, I'll say that 10 or 12 times today, make yourself less attractive to be sued, right? Lawyers in these class action lawsuits, they're like the rest of us. They look for the best case, one of the biggest dollars, the one easiest to win. If you start layering in lines of defense, if you're not quite as obviously vulnerable as the others, your odds of becoming a target go way down.
Great. So
money-wise, sorry, without any specific numbers, I will say that, the look back, the statute of limitation is, I believe, 6 years. So if you're found to be in a breach, they can disgorge you. They can seek everything that you've profited or gained or cost your employees over the past 6 years, not just what's kind of going on this year or what happened. So depending on the size of your firm, that certainly gets into the 8 and 9 figure range pretty quickly. Like it's big.
All right. Well, now we're going to talk about where does the risk show up and who are the key stakeholders in this equation. So historically, employers have really been at the center of this. And now as we sort of talked about it, the definitions are starting to shift and to change. And so it's important to know who controls decisions, who bears that fiduciary risk, who's acting as a de facto fiduciary, and those definitions seems to be changing and blurring the lines. And so we want to unpack a few different cases that show the examples of where the lines are starting to blur here. Tim?
Yeah. So again, what does the Cunningham decision mean to vendors and some of these partnerships you have? Again, I'm looking at this mostly from an employer standpoint right now. That's the lens I've got on. So again, you're going to need, think 406 and 408. You've got to have vendors. You need to use them. Some of them are more vulnerable than others. I should also point out here, regressing a little bit, you can't just blindly say, I hired somebody to do this and they failed me, so it's their problem as a fiduciary. You are going to be accountable for managing them, again, with some type of prudent process, not just blindly relying on them. What we've got here are some of the, borderline, arguably necessary vendors or partners that you need to work with, along with where there's quite a bit of risk. So TPA, of course, is a big one. We could talk about that the entirety of this call and some of the relationships they maybe do or don't have. We'll talk about some of the places where in the contract they may have discretionary authority that you may or may not be aware of. Same thing with PBMs and networks. Specialty networks is where we focus. I'm going to talk about that at the end of the call. And then you're going to see in the United lawsuit and the Schlichter-Bogard, where some of the consultants, brokers, and analytics vendors come into play, and where they've, in my opinion, again, maybe created some fiduciary risk for themselves.
Mm-hmm.
Okay, I can keep going. So, again, 406, 408, what's allowed? Is the service necessary for plant operations? I think everybody we just listed in that previous slide, pretty much necessary, right? It's going to be hard for somebody to say you don't need one or more of those. What really comes in is it reasonable? And again, that's a surprisingly common term, reasonable. You'll see that in the law. You'll see that in court decisions. It's obviously open to some subjectivity and interpretation, but a lot of it's going to have to do with benchmarking, what else is available. Again, did you have a process that looked to determine if your contract and what you're paying for it is reasonable? Okay.
Mm-hmm. So what I'm hearing is that lawsuits kind of cluster around three things. They cluster around high dollar spend. They cluster around where there's high price variability in the procedures that are taking place. And they also cluster around where there's unclear or kind of conflicting incentives based on what we've talked about. Would you agree? Is there anything else that you would add, Tim?
Yeah, that's accurate. I'll just add some rationale for kind of why things are going that way. Again, I mentioned most of the folks that I'm aware of that are working in the space and the legal firms that call me kind of poking around, class action lawsuits are usually funded by the law firm. You as a plaintiff, anybody's ever seen Erin Brockovich, right? She didn't pay the lawyers until they won the case. So they go out and they actively recruit plaintiffs, your employees potentially. But what they focus on, they're running a business just like the rest of us. They need an ROI. So they're going to look for where's a lot of money aggregated. Is there a lot of employees? Is there a lot of damages or variability? Damages linked directly to variability. So that's great. If I can go out and get a hip replacement for $1,500 and maybe I could have got it for $1,200, they're not probably going to go after that. What they're going to look for is really high volume or really high dollar. We work in the high dollar space, things like organ transplants, bone marrow transplants, expensive therapies like Sovaldi and cell and gene therapies. They're going to look at that, or they're going to also congregate around things like PBMs. A lot of those lawsuits you'll see, hey, I, as an employee, I don't like what I pay for my prescription drugs. Why is that? That's a pretty universal complaint. Everybody's getting medication. Everybody thinks they're paying too much. So the frequency of that is very, very high. So it's really, again, a function of where's the most damages, where are the most dollars that makes it worthwhile to go after a multi-year, very expensive class action lawsuit for a firm.
I do want to unpack the last point here, the possibility that somebody other than the employees is benefiting from this in an appropriate or derivative way. Any thoughts on where you've seen that, or yes?
Yeah, so that's going to get scary. And we'll show you an example. You know, I'm not picking on Mercer, but they got named in the United lawsuit from Schlichter Bogard. That's one. Another one you're going to see, and unfortunately, this gets very technical. Buried in your healthcare insurance contract, your TPA or ESO contract, is very likely some things that are benefiting either the insurance company in a derivative way, or perhaps yourself in a derivative way. I'll go off script a little bit. There's a lawsuit against the University of Rochester as an employer, where they are being sued on an ERISA basis simply because they offered a bad option with no benefit to it. So, and this goes under the derivative benefit theory, what they have is a PPO plan, and they had a related HSA option on that PPO plan. And the law firm involved in the employees determined, hey, basically in no scenario is this HSA plan favorable to the PPO plan. Therefore, it's a financially dominated product, and the employer is indirectly benefiting because anybody that selects that plan, they've now shifted some of the healthcare costs to the employee inadvertently. Doesn't really matter what your intent was. You're benefiting in a derivative way. You've got exposure.
Happy to send more detail. I was reading that over the last few days, and it's fascinating to me that you can get sued just for giving the wrong option or a worse option.
Essentially, you're offering, optionality, right? But when you dig into how that plan actually adjudicates and how those dollars flow, allegedly there's no benefit to it. So probably a case where, whoever designed the plan, not the employer, maybe they knew that, maybe they didn't, but you've gone out of your way to offer your employees additional options, and you're getting sued for your good act.
Mm-hmm. So let's talk about the employer, Tim, and can you tell us a little bit about this United case?
Yeah, so a couple things we've alluded to, and again, this is, not anybody on the call doing this. This is the lawsuit that was filed, one of the 4 filed last December. These are the allegations in the lawsuit and some of the things they're going after. So number one, simply nobody compared premiums for similar plans. Now, whether they did that or not, it's hard to say. But the real scary part or implication here is, what's not written clearly is, if you didn't compare them, even if you made the right choice, simply not having that process and not doing the comparison is potentially a fiduciary breach. In fact, by the letter of the law, I would say it is. Now, again, if there's no damages involved in it, if you didn't harm anybody, then you're probably in decent shape. But if you didn't compare rates and you can't prove that you compared rates, that's claim number one. Number two is really more performance related. Really, how does this plan perform? What's your MLR compared to the benefits, compared to the premiums received? A little more technical, but that gets into direct financial impact. And then 3 gets a little bit scary again. So this is another, maybe indirect benefit to the employer and a direct benefit to the broker. So the claim here is, okay, we understand that you need to use a broker. In this case, I think on our next slide is, I think it was Mercer, correct me if I'm wrong, but they had a very high commission on whatever product they sold them, much higher than what you typically see in the market. That goes back to that standard of, was it reasonable? Probably not, allegedly not, right? Maybe there's a reason it was 36% instead of 19%. Maybe they can justify that, but it's, that's the argument that's being made, is it wasn't reasonable. The other part of that, again, is there's an allegation buried in here that says, well, also, since the employer allowed, the broker to make that kind of exorbitant commission, they probably got products and services and had lower fees from that broker for some of the other things it did for them. So they've indirectly benefited. They received a derivative benefit as well. So those are the three claims, or three of the main ones in that particular lawsuit. Again, very, very kind of scary stuff.
So if I were to summarize what I heard, is that passive oversight is not a defense.
Yeah. Ignorance, what goes back to the Romans, ignorance is not an excuse. You're the fiduciary, whether you like it or not. So you've got an obligation to prevent this stuff.
Mm-hmm. So I'm curious how this affects some of the other stakeholders. You mentioned the broker and Mercer.
Yeah. So this will all have to wait and see how it plays out in the court systems. This could be anything from the law firm putting pressure on partners to a legitimate claim. Candidly, I don't know, and I don't know what the courts will decide. But kind of the open question here is, okay, we know, where we think we know the employer's a fiduciary. Is the broker also a fiduciary in some way? And again, I think a lot of that's going to come back to, do they have discretionary authority? Are they pushing people inappropriately for their own benefit? If they don't have discretionary authority, maybe they're okay. If de facto they do, or somehow they've got a relationship or an agreement that's, really causing them to make the decisions, then they might be at risk for the fiduciary as well.
Mm-hmm. And then let's talk about the plans, the TPAs, the ASOs.
Yeah, and this is, I don't know if I want to say an open area at this point too, but a battleground I see coming up. I think everybody's first reaction as an employer would be, look, I got to rely on the plan, or I'm relying on my TPA, ASO to help me navigate this stuff. That's what I pay them to do. And I think there's a lot of merit in that argument. But again, it's going to come back to, do you have a process to manage them? Are you putting scrutiny on them? Just blind reliance or ignorance is not going to save you. At least I don't think it is. And let me give you a couple of examples that I typically see that would be risk areas, or areas you should look for. First, just in the top paragraph there, I read a lot of employer contracts and employer payer contracts, TPA, SO contracts. They almost invariably, if not once, 4 or 5 times, will say, we are not a fiduciary. That's probably not going to save them. Unfortunately, in other areas, I've gotten pretty familiar with contract law, and just saying you're not a fiduciary, if you're
doesn't mean you're not.
Right, that's not a get out of jail free card. That's not the golden ticket. If you have discretionary authority, you're probably a fiduciary, right? Whether you say you are or not. I see it a lot, and again, this is my space with health rate, in the COE and carve out space. If you look through your contracts and look for any kind of specialty care, any carve out, anything that requires, not normal standard of practice, a lot of times it's going to defer to the TPA or the plan to say, we'll select a COE, we'll evaluate them, or, we'll get you a better rate, but it's kind of our discretion, or they're effectively making that decision.
Mm-hmm. And what I'm hearing in that is that operational control creates that fiduciary exposure then.
That's right. Yep.
Yeah. Okay.
Yeah, keep going, sorry.
All right. Well, what I was going to say is, based on everything that you said, what I'm hearing is, historically, it was the onus was on the employers, and then based on all these lawsuits, really now everyone is affected and exposed to ERISA risk. So that responsibility is shifting, that risk is shifting, and potentially can affect all of the players in this equation.
I think that's right. And we're basing that on actual lawsuits that have been filed. We'll see how successful they are or aren't. But again, I think everybody on this slide in that purple circle has been named in one or more lawsuits. And at a minimum, they're going to have to respond and defend themselves. The other thing on this slide, you might see the CHRO called out. I've never seen anybody go after a named employee, but again, I think by the letter of the law, that's, there's potentially some exposure there, right? You are often functioning as a fiduciary, perhaps even outside the responsibilities of the company. So again, I'm not a lawyer, but there is some exposure there.
And so we're shifting from institutional to personal responsibility in these cases. So translation, please. We've we've said a lot. What is the pending risk? I guess the way that I'm understanding is there's two kind of key pieces to keep in mind here. One is the burden of proof piece, and the other is the affirmative defense. So can you, in plain English, explain to us what these two mean?
Yeah, the short answer is now you have to prove it proactively, right? So you have to be able to demonstrate to any potential adversary that you're affirmatively doing this stuff. You have a prudent process. You are being a good fiduciary of healthcare dollars. Just you have to have that ready, or you're exposed. You're exposed for a lawsuit.
Okay. So what can all of our amazing attendees do now to prepare themselves to get set up and potentially manage and manage the risk?
Yeah. So I am, as usual, I apologize for being a recovering management consultant. I spent a lot of years at PwC and Accenture, but step one is try and get a handle, assess your risk. And really what I would focus on there is, where does the discretionary authority lie? Are you making PBM decisions correctly? Have you delegated that to your TPA or ASO? Is that still your exposure, even if you've delegated it? Are you monitoring it? So figure out, again, not so much what the decisions are, but where the decisions are being made and who that discretionary authority is mapped to. Get a handle on your landscape. The second two bullet points there and clarify is just document everything and push your partners. They're not going to like it, and we've probably got a few in the call, but ask your broker how they're getting paid. Ask them if they're getting commissions on the products they sell you. You have to ask what those percentages are. Same thing with your TPA, ASO. I know those people don't always like to share data. I know you've asked them before. Send it over. Ask them again after that, and document that you're asking them. If you don't get it, again, I'm not a lawyer, but I think you're in a much better position to say, I've got a prudent process. I'm doing everything in my power to check and monitor this. If you're being blocked by a third party, that's an argument to be made there.
The create the infrastructure one was interesting to me, and actually Jennifer Stanley, who's on the call, a lawyer, an expert in the space, we're talking about the importance of having a benefits committee, and really having multiple folks in leadership positions being a part of that decision making infrastructure, to be able to have that defensibility, and then so you've got the people power, and then the other end is the benchmarking, is getting the data, the power and the data to show that you have benchmarked and you are doing your due diligence and picking the right partners, and then picking the right networks and plans, and offering the right benefits to your employees. Anything else on the infrastructure piece, Tim?
I'll just to get off the fear mongering a little bit on my part, I'll just add that again, some of the takeaways here are really prudent process and documentation. So yeah, maybe you're not able to achieve the world's best rate on your PBM spend or your catastrophic claim spend, but if you've got a process where you went out and you tried to benchmark, you went to the market, you followed a reasonable and prudent process, even if you didn't get the best results, you're in much, much better shape than if you've done nothing, or even if you did something and you can't document or prove it. So show your work.
So sticking to my word around highlighting solutions that are actually solving the system, not just making problems get bigger and go faster, and not really solving the underlying issue. I'm really excited to talk about a solution in the space that can potentially solve and help you prepare for some of this ERISA risk. So Tim, can you tell us about Health Rate?
Yes. Let me give you a little bit of background, just a little bit of a founder story here. We didn't actually found the company to get into ERISA or to defend against this risk specifically. What we found, what the platform does is essentially it evaluates market rates for high cost procedures. Again, things like cell and gene therapies, bone marrow transplants, organ transplants, some types of really expensive cancers, and cardiology. But there is a market out there, believe it or not. There's a bunch of specialty networks that you very likely have access to, whether you know it or not, with highly variable rates. So what Health Rate does in real time is it goes out, it evaluates all those complex contracts and those rates, and it will tell you something like, hey, and you'll see the screenshot here, I've got a liver transplant at Ohio State. I know that both Optum and Cigna, for example, have specialty networks out there. I want to compare those two contracts to each other, see which one's going to be the most cost effective for me. And that's what our tool does, and just documents that we've done that. The next slide.
Yes.
So, where we fit into ERISA, or one of the reasons we think we're a great first line of defense, is a lot of those reasons we talked about on where these law firms are focusing. What's an easy target? So again, in my mind, even some of the PBM lawsuits that are a relatively large target, those have had varying success. Some have been dismissed and brought back. It's really hard. I think one of the things they're struggling with is linking the financial harm directly to the employee, because sometimes it's small dollars on those individual drug spends. Where we look is on the high dollar, high variation side. So I'll show you some data in a minute here, but something like a heart transplant can vary. The case rate can be $100,000 different pretty easily. We see that a lot. At the exact same provider, with the exact same doctors, at the exact same health system, nothing's different than other than which network contract you pick. Right? So that's an immediate direct impact, hard dollars out the door that you probably didn't check on. A lot of people don't know to go look for those prices.
So just to clarify, Tim, basically what I'm hearing is, if I'm the patient, you're not asking me to change my physician. You're not asking me to change my course of treatment. That's right. You as an employee are going to enable me to continue my course of treatment with the physician that I want at the hospital that I want. It's just that you're helping me or helping my employer negotiate a cheaper rate for that procedure. And maybe an example would be helpful to talk through.
Yep. And I know this one's a little bit of an eye chart, but I'll walk you through it and you can zoom in after the call at your leisure. The two spreadsheets you see on the right, that's actually the same spreadsheet, one row zoomed in. That is publicly available transparency data. So that is a No Surprises Act file that I pulled from the University of Michigan Health System. And what you're going to see in there is a simple price check. And the one called out is a pediatric heart transplant. You're going to see, if you go through the Aetna network, the case rate is $360,000 and change. If you go through another network called Interlink, which, by the way, does a really nice job, they are a publicly available network. You can have access to them in less than a week if you want it. It's $195,000. Okay, same hospital, same doctors, nothing different other than which network did you go through and which rate did you get. So, a couple of things here. One, you almost certainly have access to multiple specialty networks, again, whether you know it or not. I know that there are clients, that there are Blues plans that use Cigna, there are Blues plans that use Optum, there are Blues plans that use Interlink and ETS and other, right? So you're probably not tied into your provider, even though you might think you are. And again, your plan probably has some discretionary authority in there. But the problem becomes, okay, if this was the case, what's your defense going to be to why did I pay $366,000 for something I could have got for $194,000? How do you explain that away if you're facing a fiduciary breach?
And I'm curious, Tim, so how does the health rate platform differ from me just pulling up a transparency file just like you did here? Like what would I get that I wouldn't otherwise get or be able to find on my own online?
So a couple things. One, the data changes a lot, and it is relatively hard just to even get to the spreadsheet point. But more importantly, this is not the total cost of care. This is the simple case rate for the actual transplant itself. You're going to have a lot of pre-transplant cost, a lot of post-transplant cost. And I don't think any of my network partners are on the phone, but those contracts are complicated, maybe even obfuscated, but they charge varying percent of charges as pre and post. They have got different outlier provisions and triggers in them that really make it quite difficult to determine what's my total cost of care going to be for 12 months of a heart transplant. Our platform demystifies all of that, and we'll give you a rock solid, here's what it's going to cost you for that patient on these 2 different contracts, or these 5 different contracts.
Mm-hmm. And if I have let's say an employee that's sort of responsible for managing and checking these rates, what is their experience like if they're, again, trying to do this on their own versus using Health Rate?
Yeah, it's virtually impossible. And it's the whole concept behind why I founded and built the company. One, very few people know about this. Even health plan executives, a lot of times at regional plans, won't even know that they have this flexibility. Two, you've got to know what the universe of networks are. And we can share a network map for you folks that we provide on our website for free. So you got to know first you got to know it's a thing, then you got to know where to look. And then you've got to be, frankly, probably some type of actuarial experience, as well as data extraction experience, to try and figure out what a likely series of claims for a heart transplant or a bone marrow transplant is going to be, and how that's going to price and reprice against those contract terms. So it's really very difficult, if not impossible, to do it without some kind of specific tool or an analytic and actuarial team.
Mm-hmm.
And I'll just add on that, again, not to fearmonger, but the other side has that. The hospitals have that. The health plan have that. That's why these contracts are structured this way, right? A lot of times they'll offer you a low case rate because they know they can make it up with some of the other provisions. And they know it's going to be real hard for you to figure out which one's better.
Mm-hmm. So the looming ERISA question.
So, we are, of course, not by far any kind of silver bullet or a blanket solution to ERISA. It really kind of goes back to, what I talked about, make yourself less attractive as a target. Mm-hmm. These are very high dollar. In my opinion, they're somewhat easier to call out or prove than some of the other lawsuits that are going on. I know there's a lot of interest in these cases because, again, I can't disclose names, but there are 3, maybe 4 large national class action lawsuit firms that call me on a monthly, if not weekly basis, a couple of them, talking about how does this market work, what are the damages, what are the prevalence and frequencies of these things. So, I think it's coming, right? I think you're going to have to be able to respond. And again, if you have tools like Health Rate or one or more of those, you start to get real difficult to get at. There's much easier targets out there that where people, frankly, are not aware of this or are not doing anything.
Mm-hmm. So the question that remains, how does a plan demonstrate that its fiduciary process was prudent? Is what needs to be really navigated very intelligently. And so how do we leverage Health Rate to help answer that question?
Yep. And again, I think we're a great first line of defense. What you're going to see here, this screenshot, again, is actual real data. This is a liver transplant of a medium severity type patient at the same exact provider, the same hospital in the Midwest. There's a $300,000 north of that difference in what you're going to pay. That's not, for some of the savvier people on the phone, that's not billed versus allowed. That's one discounted network versus the other. So, again, if you didn't do the math on this or do the process and somebody comes back and says, why are you overpaying by 6 figures, sometimes 7 figures for a case, walk me through what process led you to that decision, you have a hard time coming up with an answer, right? Your answer, I would speculate, in today's world was probably, I wasn't aware of it. I pay my TPA to do that. They actually had the discretionary authority. Maybe that's a defense, maybe it's not. I wouldn't roll the dice.
Great. Well, with that, I would love to open it up to questions. And, kind of summarize again, today's discussion isn't really about predicting litigation outcomes or anything like that. And again, we're not lawyers, but it's about recognizing that, governance expectations are really changing and evolving, and risk is really kind of there's blurring lines now about who carries that risk. And so I think it's important to have the conversation. I'm very curious to get questions from the audience. Okay, we have a question. Can you talk about how you action the savings you find on a claim? How do you work with TPAs and point solutions that are part of the plan prepayment?
So we definitely get involved prepayment. It's a little bit of a difficult conversation with something like a transplant because it does span so much time. And there is some claims repricing involved. But essentially, here's the process. You have, let's use a let's stick with liver transplant since it's on the screen. You've got somebody seeking approval for a liver transplant. Somebody at the TPA, usually somebody in UM or CM, is making a benefit determination and a medical necessity determination. At that point, that's when you use health rate to say, okay, if it's medically necessary, if it's a covered benefit, now I'm going to shop the networks available at whatever provider I'm at to find the best rate. At that point, you make a referral to that network. That's how, generally most plans or TPAs are already doing that. It's just they're not shopping it. They're defaulting to one or more networks. So they use Cigna all the time, or they use Optum all the time, or they don't actually compare the math on those on a case-by-case basis. So when you're approving that case before I don't want to say blindly, but just follow your default referral pattern, maybe you fill out the Cigna form or the ETS form instead of the Optum form that time. And that happens before, since it's at the UM phase, before the dollars go out the door. So the actioning of the decisioning on the savings, we are not an audit recovery firm. We're not reclaiming dollars that went out the door. You just get lower repriced claims right out of the gate, right, before they ever get paid.
Mm-hmm. Great question. We have another one. When HealthLink provides transparency data to the self-funded plan sponsors, where do you believe your responsibility ends and theirs begins?
Well, boy, there's a lot in that question in terms of transparency data, right? So I don't think so. We're not kind of a pure provider of transparency data. There are a number of firms out there that, one, you can go look them up yourself, which I wouldn't recommend. They're a nightmare. Two, there are firms like Denison Data and Turquoise that will just sell you queryable transparency data. I don't think that, unless somebody writes a foolish contract, there's not going to be any discretionary authority in that contract. Those are going to be written up typically as just, this is information only. Use the data at your own risk. We have no legal obligation. Don't think there's a lot or any fiduciary tied to providing data or providing information. It's who's making or influencing the decision. So if I cross the line or anybody else providing data cross the line into, okay, I've shown you that one of these is $300,000 better than the others, that's fine. If I tell you should absolutely go with number one, or we're going to go ahead and make that referral for you based on that, now I'm a fiduciary in my mind, or now I put myself at risk. So candidly and selfishly, I try real hard not to be the decision maker, right? We don't do that. We're just giving you the facts. You make the decision. We will certainly implement it for you. We will run the process for you, but the decision is not ours under any circumstance. That's got to be you. That's got to be the patient. That's got to be, somebody else, whoever owns the dollars.
Great. Any other questions or follow-up questions to the ones in the chat? All right. Well, I'll speak for myself. Thank you so much for taking the time today. And if you have further questions, please feel free to reach out to us. And we would love, we're happy to take any follow-on questions about the platform itself. And again, if you need more detail on ERISA specifically, happy to recommend legal counsel as well.